The defense is ready to proceed, Your Honor, or the petitioner.
Uh, yes, sir.
All right. We are calling this motion's hearing for a Franks case number 2148450. The defense counsel, Mr. Cyrus Hunt, has motioned for this hearing to take place. And Mr. Hunt apologies that this was not done last night. Time constraints left me very little room for maneuverability. So I'll just go over a few things. Now, the exclusionary rule prevents police that have acquired evidence because of a Fourth Amendment violation from submitting the illegally seized evidence in a court. The main purpose of that rule is to deter government officials from benefiting from any violation of an individual's Fourth Amendment right. Now, the effect of the exclusionary rule is to exclude not only the evidence seized pursuant to the violation, but also to exclude all derivative evidence obtained because of. Now, as the search warrant hasn't been executed yet, this gives us an opportunity to analyse the warrant where no violation has taken place, but it does allow us to prevent a violation to take place if that would be the case. So the master affidavit for this warrant was submitted by Detective Arnold. And just for note, search warrants can be voided if probable cause was based on a false statement in the affidavit. Now, this hearing is evidentiary hearing, and the defence has to show that a false statement, either knowingly and intentionally or with reckless disregard for the truth, was included by the affiant in the affidavit. Now, if the allegedly false statement is necessary to the finding of probable cause, then the Fourth Amendment, which at this point would be incorporated by the 14th Amendment, would ensure that the warrant is found invalidated. Now, if at this hearing the allegation of perjury or reckless disregard is established by the defence counsel by a preponderance of the evidence and with any false material set to one side, if the affidavit's remaining content is insufficient to establish any probable cause, then the search warrant would be voided in full. All right. Mr. Hunt, I'm going to hand over to you.
Yes, Your Honor, apologies. If I can just one moment. Counsel, may it please the court? There's a couple of reasons as to why we submitted the Franks motion yesterday evening. For starters, to briefly go over the case, I will attempt to state what had happened during the case directly from the police report. As stated inside the police report, police were pursuing a speeding vehicle. Officer Maurice Boriselli later joined in off the pursuit when it was coming off the street of Roy Lowenstein. On that street, the vehicle Mr. Montana exited the vehicle where he was inside of essentially the Valley kiosk at the parking garage of Roy Lowenstein. Officer Maurice Boriselli approached Carlos Montana and ordered that he provide his identification. Mr. Montana responded that he was the passenger of the vehicle and essentially that he did not see the reason as to why he was being asked for his identification. Officer Maurice Boriselli stated that he was failing to identify himself. Later on, Mr. Montana stated that his name was Carlos. Officer Tom Boriselli responded that he needed his surname. And Mr. Montana continued to state, or in a loud way, that he was the passenger. Why do I need to provide my identification? I was the passenger. Mr. Montana did not give his last name. Maurice Boriselli then stated if he could face the wall because he was wearing a mask. Maurice Boriselli was attempting to perform a Terry frisk for the reason that he was wearing a mask. Maurice Boriselli stated that Because he was wearing a mask, it gave probable cause to Terry frisk the defendant. Mr. Montana refused to face the wall. He kept stating why. Maurice Borselli then stated that he was refusing to obey a lawful order. Mr. Montana stated that he was not consenting to a search. Mr. Borselli then tased Mr. Montana and brought him under control, as stated inside the report. The report continues to state what was found on him, and I won't continue to go on that because I believe it's quite clear from the evidence. He had a compact rifle, he had ammunition, oxycontin, so on and so forth. Or oxycodone, sorry. The reason why we submitted this motion is for a couple of reasons. The first reason is we respectfully submit to the court that where Mr. Montana was seen with the mask was not a public area. As stated inside the police report, he was at the Valet Kiosk of Roy Loystein. And in that location, it's an apartment. The apartment, not owned by the state, not a public area, it's owned by the I'm having a loss for words here. Sorry, by the landlord. It's not in any way the apartments that he was at owned by the state. It's in sole possession of whoever owns that property. We'd state to the court respectfully that where Mr. Montana was told that he had PC to Terry frisk because he was wearing a mask is untrue because he was not in a public area. It states inside the Penal Code, and if I can directly quote it, it states under miscellaneous laws, definition and notes, in subsection 4, it states wearing a mask, hood, or other concealment device in public areas is outlawed. No persons or persons over 16 of age shall, while wearing a mask or device, wherever any portion of the face that is so hidden, concealed, or covered as to conceal the identity, to enter up and appear any lane, walk, alley, street, road, highway, or other public way in the state. Wearing a mask in public areas constitutes automatic consent to stop and identify a person. That person must comply with the frisk of the other clothing for weapons and must present state identification to law enforcement. So as for the first grounds of our Frank's motion, we respectfully state to the court that where Mr. Montana was, he was not in a public area, thus not constituting probable cause, as Maurice Borselli stated, to Terry frisk the defendant. With regard to the second point, if I can directly quote from the warrant, I can provide a copy to everyone here. If I may have a moment here. Raiden, do you have a copy of the warrant, or would you like one?
I have one.
Gunner, do you have a copy of the warrant?
Could you pass me a copy?
Yeah, I've got one.
Yeah, I can pass you a copy. Did you get that?
I did, thank you.
Your Honor, the grounds that the warrant was submitted was for illegal weapons and paraphernalia. I'm going to briefly touch on the order that was submitted by Your Honor. But before that, just to go over the grounds of the warrant. The warrant was stated that it is possessed by a person with intent to use it as means of committing a public offense or is possessed by any other to whom he or she may have delivered it for the purpose of concealing it or preventing its discovery. So basically, from the warrant, it's stating that, well, we're asking for a warrant so we can retrieve this firearm. What I don't understand is to why they did retrieve the firearm. So I state respectfully to this court that the warrant was submitted on unlawful grounds, and it was submitted on the grounds that they were going to retrieve a firearm, which was then a misrepresentation of the facts because the officers had already had the firearm. They weren't retrieving any firearm. With regard to the, I believe it was the order that was submitted by Your Honor, if I can just pull up a copy momentarily. On August 29th, Your Honor stated, after the events of yesterday, some people had no other option but to take up arms. In order to assist in ensuring that everyone was protected, the military law enforcement agency provided some citizens and trays with firearms for their own safety. Now, incidents come up. Anyone who hands over legal firearms or police-issued equipment to any law enforcement agency within the next 24 hours will not be charged or having them in possession. Names of those who have been supplied, tracked, and then this is where it states, in a bid to help curb the misuse of any of these items, possession of police equipment will be temporarily held until trial status, and possession of a Class 3 firearm will be once again temporarily returned to a mandated search and seizure. I must give credit where it's due to Mr. Hall. It was brought up that, well, we'd respectfully submit, and I understand if Your Honor does not agree, but that the law was never enacted. It never states a day in which the law will take act. Therefore, we'd submit that the law was never enacted. But regardless, to go back to the warrant, we'd still state that the warrant, as submitted, was a misrepresentation of the facts, because it states in the warrant that they were getting the warrant in order to retrieve property that was means in the use of committing a felony offense. Not to repeat myself too much, so I'll say it one final time. But again, we just state that the police officers misrepresented the facts when they submitted the warrant on the grounds that they were going to retrieve a firearm, because they already had that firearm. It was already found on the surface. Sorry about that, Your Honor. That's all from the petitioner. We'd reserve
Your Honor,
15 minutes for rebuttal.
I
Oh,
do just
sorry.
have a couple more points, if I may, Your Honor.
Yeah.
Thank you. Of course, we respectfully submit and understand that this court was the one that did, of course, write the legislation that was submitted, and this is, of course, in regards to the possession of Class 3 weapons or police-issued equipment. Now, of course, we do understand and can give credit, Your Honor, to yourself for the writing, and we wouldn't necessarily wish to overly critique the legislation. However, there are a couple necessary points that we do need to bring up. Since this law, or legislation rather, this bill, is what the officers were going off of when they attempted to get this search and seizure warrant. Now, if this court is to understand that the search of the defendant, as well as the search warrant itself, is valid. If this court determines that that's the case, we disagree. But if this court finds that that is the case, that both of those steps leading up to this are valid, we still determine that this law is invalid and unconstitutional in nature. Now, overall, any sort of law needs to be enacted. As Mr. Hunt sort of started to go into, there is no specific dates as far as the specific section when it comes to possession of police equipment or Class 3 firearms. It doesn't state anywhere as to when that part of the law comes into effect. It doesn't go into specifics, for instance, of what may be searched, what a mandated search and seizure actually is, who may request one, for what purpose, under what circumstances. And because none of that is actually specified in the law, any sort of attempt to acquire a search and seizure warrant based on this law, therefore, is unlawful. Specifically, of course, when it comes to any sort of search and seizure, there needs to be probable cause to determine that a crime has been or is in the process of being committed. When it comes to a search and seizure, it must be determined that in the specific property, the owner of the property is breaking some sort of law, or they have some sort of evidence of a crime. Now, again, as Mr. Hunt went into, the defendant in this case, the evidence of a crime was already acquired by law enforcement. The firearm that they found on his person was already in their possession. There was no other sort of inkling that he had other firearms in his properties, his vehicles, or on his person. What they acquired was all that he had. Now, of course, with that in mind, There would have been no actual constitutional basis for a search and seizure warrant. And of course, therefore, in and of itself, this law is unconstitutional. And again, just to clarify, this search warrant was for all of the defendant's vehicles. Now, again, to make this quite clear, this law doesn't state at all what may be searched and or seized. Nothing is specified as to whether it's vehicles, properties, person. And because it is so unclear, so vague, it could be interpreted in almost any way. And because of that, it should not be upheld. Overall, the statute shouldn't be enforced. Search warrants and any other mandates required by the statute shouldn't be allowed to be pursued because of the vagueness of the statute, that it wasn't actually brought into effect, and that overall it is unconstitutional in nature. Thank you, Your Honor.
All right. I'll hand over to the state for a rebuttal.
Thank you, Your Honor. With regards to the public area, that I don't know whether to say the defense or do you have a different name today?
They're the plaintiff.
The plaintiff.
Or the petitioner.
We'll go with petitioner. That the petitioner said that he was not in a public area. But they also did state just before that the suspect was in a car driving up the street, which I believe is public, and then went into that area, which may not belong to the state, but it is freely accessible by all, which by definition makes it public. So I think that covers that. The whole point of this search and seizure is not to retrieve the weapon that they already have retrieved. It states in the warrant that they believe, there's probable cause to believe, that Mr. Carlos Montana may be holding more illegal weapons and weapon paraphernalia in one of his many vehicles. We were not saying we want to retrieve the weapon we already have. It's in black and white on the warrant that the police believe he's concealing more. Hence the warrant. With regards to whether the law is legal, I will leave that up to Your Honor itself. Yeah, I think that's about it for us.
All right. I appreciate it. Anything from the petition?
Yes, Your Honor. I'll make it quite brief. If I get one. Sure.
Before we continue, Your Honor, maybe we approach the bench.
Yeah. Both sides can
Thank you.
come over here because the microphone can't be switched on. What's up?
Your Honor, I will remind the clerk that the district attorney's office doesn't actually handle any search warrants. Respondent in this case is looking to recuse both of the petitioning counselors, but have to be shown that in some sort of way we are conflicted, right? That there is evidence to show that somehow we were involved in this case previously on a different part representing the state, which we weren't. And because, of course, there's no. Unless it can be shown that we actively worked on this case, or any other case that we may be, of course, alleged to be a conflict of interest out of, necessarily, then just us, quote-unquote, having access to the information doesn't mean we were involved in the case, doesn't mean we worked on the case, doesn't mean we're at any sort of advantage or conflicted in any sort of way.
So here's
Hello.
where we're on
what's
September
up?
the 6th at
I'm a court, mate. What's up?
12:30 p.m. in the afternoon, Cyrus Hunt submitted his resignation.
Alright, I get you.
District Attorney's
I'm at court, mate. I can't respond, but just do like a 911 and somebody will get up there,
filed on
alright?
September the 6th at
Thanks, bro.
6:41 p.m. And the case, again, we're looking at different. So for this, I'm going to say that Mr. Hunt is eligible to represent the client just based on the time. By the time he had left the district attorney's office, he would have had no knowledge of any of it, and he would have not had any involvement in the case whatsoever. Let me look at Mr. Hall. But coming back, the warrant itself it's a byproduct of the case, but it's not directly related to the case. The district attorney's office, I mean, you know yourself, you have no interactions with search and seizure. It's completely outside of your scope. It goes from the LEO straight to the judge, and then from there, if there's an outcome to it, then you would prosecute, but that's after the warrant had been executed. Based on the timestamps, the resignation, the fact that it's completely separate from the case itself, and is out with the DA's office's purview until after it's executed, I'm going to say that there's no reason to recuse them, and we can continue with the execution.
Thank you, Your Honor.
Let's restart.
Does the petitioner have anything else they want to bring to the?
Yes, Your Honor. Just briefly rebut the points that were made by the prosecutor. Firstly, I'll go in order of the arguments that he brought. He firstly stated that the car I believe we're going to get into some difficult privacy laws, and we could probably be here arguing here for hours whether or not privacy law would apply here. But the defense, or sorry, the petitioner, would state respectfully to the court that inside of your vehicle, you still do have the expectation of privacy. You're still bound by privacy laws, and you're still in your personal vehicle, your private space. We'd state that while he was inside of the vehicle, he was still had the reasonable expectation of privacy. And the time that he didn't, he was on private property not owned by the state, which was not rebutted by the prosecutor. With regard to concealing more weapons, and I'll directly quote it. It states, it is possessed by a person, or sorry, I should probably read the first part as well. Yeah, it is possessed by a person with intent to use it as a means of committing a public offense, or is possessed by another person to whom he or she may have it delivered for the purpose of concealing or preventing its discovery. I'm sure a lot of us will have different interpretations of the text, but I'd respectfully submit that how the warrant was submitted, how it was represented to the court, it was represented that this weapon that they're describing was used in the means of committing a public offense that Mr. Montana was concealing or preventing its discovery. That's how I would interpret the search warrant, how it was submitted. With regard to, actually, I believe that was the final point. With regard to one last point, with regard to what Mr. Hall mentioned, it does state for the first part, I believe it says something along in the next 24 hours for one specific paragraph that this will be enacted. However, for the class 3 portion, it did not say when it was going to be enacted. So that's what we'd submit with regard to the time frame. I believe that's all, unless Mr. Hall has something you'd like to add.
I believe that's all, Your Honor.
Thank you, Your
Honor. The two names mentioned on the affidavit were Officer Gallo and Officer Boscarella. Are either of those here?
They're both here, Your Honor.
Yes, Your Honor.
All right. Officer Boscarelli, can you approach and just... I just need to ask a few questions.
Yes, sir.
Honor. Your Honor, for clarification, will we have the opportunity to cross-examine Mr. Boriselli?
Yeah, both sides will have the opportunity to.
Where would you like me to stand, sir?
I mean, you can just stand next to the DA.
Okay. Can everyone hear me okay?
Yes, sir.
Yes, sir.
All right, so I just have a couple of questions. When you told Mr. Montana to face the wall because he was wearing a mask, it stated in the affidavit that you said you had probable cause for a Terry frisk. Can you just elaborate on that?
All right, so Mr. Montana was being chased by the police in a vehicle that turned off Roy Lowenstein into a public car park. He jumped out the vehicle in the lower part of the car park and then ran up towards the bit where you pay for your car parking, and that's where I caught up with him. He was wearing a mask. I originally just wanted to speak to him and see if he had anything to say, but he was immediately belligerent and uncooperative anyway, so I wasn't even able to have a normal conversation with him. The probable cause I had to Terry frisk him was the fact that he was wearing a mask, but also the fact he came out of a car that was being actively chased by the police. Whether he was the passenger or not, he still got out of that car while wearing a mask, but you know what I mean? So, yeah. Does that answer your question?
It does. I'm just taking notes. When Mr. Montana refused to consent to a sit, what was the exact reasoning he gave?
He didn't give me a reason. He just kept screaming in my face. He wasn't really even making any sense of what he said. He actually said, he posted up asking for a lawyer later on, and he said that he told me that he'd been held hostage. He'd never mentioned that at all, not once during the interaction. All he kept saying to me was, "I'm the passenger. Why? And he just wouldn't let me speak to him at all. There wasn't any reason for him not. He didn't give me a solid reason for him not taking for me not to, for him to refuse the search. I mean, he was detained anyway. That's all I was trying to say to him, was he was being detained while I investigated what had happened.
When he started making his way towards that area,
Yeah.
did he know that you were in pursuit?
Well, there was 3 police cars chasing the car, and then I was in a police car with my lights and sirens on as well. So I don't know how he didn't know that he was being pursued. To be clear, he wasn't specifically being pursued. It was the vehicle. He just got out the vehicle.
So just for clarification, he got out the vehicle.
Yeah, that was
He
fleeing from
ran-
police.
He ran up to where you would pay for the car parking, as you would say.
Yeah.
At that point, you caught up with him, asked for his identity, told him to face the wall because he was wearing a mask. For a Terry frisk, said he wasn't consenting to the search. At that point, you tased him and searched him correct.
I mean, it wasn't as quick as that. There was conversation in between. Or rather, I was trying to explain the situation why I was detaining him. Tried to, reason with him. Asked, tell, make. Tried to reason with him. Tried to have a normal conversation with him and make him calm down. He was very agitated. It wasn't just as quick as, he runs up and I'm immediately face the wall and tasing him. You know what I mean? Like, I did give him warnings. I gave him ample warnings that failing to identify was a crime. He was being detained. He had to identify himself to me. He was wearing a mask, so therefore that gave me the right to Terry frisk him. He wasn't interested in that either. So I was asking him to face the wall, and I then told him like that's failing to obey a lawful order. But yeah.
I believe the Chief Justice was paraphrasing. It's okay.
Right, okay, sorry.
Yeah, no, you're good. I don't need the Lord of the Rings breakdown. It's just more bullet points from my own note. Alright. And just to be clear, this happened in the Valley Kiosk apartment area, correct?
No, it wasn't an apartment. It's a car park. It's a multi-story car park. There's no apartments there at all. It's a multi-story car park off Roy Lowenstein.
All right. Perfect. Petitioner, you can question the officer if you wish.
Good afternoon, Officer Borisella.
It's Boscarelli, sir.
Boscarelli, I apologize. And how's your day going so far, sir?
Not too bad, sir. Yourself?
Not too bad. Okay, well, let's just go over a couple things you said.
Yes, sir.
Questions you were asked. Just to clarify, just so we're all on the same page, you'd agree that Mr. Montana was the passenger of the vehicle, yes?
Yes.
Right. You stated when you were asked a couple questions, he was uncompliant. You'd
Yep.
agree that he was compliant until you asked him for his ID, right?
No.
Okay. Then when was he uncompliant?
But, I mean, I say he was uncompliant. He, basically ran towards me, and he didn't run away. So that part of it, he was compliant. You know what I mean? But however, he was, if we were, if I was to stop you over there and we were having a conversation like this, I would say you were being compliant. You know what I mean? He wasn't like that. He was just screaming and shouting. I couldn't actually hear a lot of what he was saying because he was getting so agitated. Not that that's been uncompliant, but it is belligerence. You know what I mean?
Sure. You'd agree that in your police report, you stated, and I quote, "The man put his hands up and was compliant until 553 Boscarelli asked him to identify himself. Then he
Yep.
started screaming."
Yeah.
So you'd agree in your report that you stated he was compliant until you asked him to identify himself, yes?
Yeah, of course, yeah.
Sure. You'd agree that you never told Mr. Montana that he was being frisked because he was in a pursuing vehicle. Yeah.
No, that's not true. I told him he was being detained because the car that he was in was being chased by police. It was in an active. It was fleeing from the police, and that's why he was being detained while I investigate the situation.
Okay. You'd agree that in your police report it states, and I quote, 553 Boscarelli tried to explain the fact he was wearing a mask, gave 553 Boscarelli PC to Terry frisk the man. You'd agree that it says that in your report?
Yep.
Right. So you'd agree your report never states that exiting a pursuing vehicle was not one of the reasons you stated that you had probable cause to Terry frisk Mr. Montana. You'd agree?
No, because that wasn't the main reason. The main reason was the fact he was wearing a mask.
Sure, that's what I'm saying. You'd agree that in your report, it never states that one of the reasons you had probable cause to Terry frisk Mr. Montana was because of the fact he was exiting a pursuing vehicle.
Yeah. Do you mind if I stand on this side? I'm having problems hearing you.
Sure.
Okay.
Sorry, Your Honor, are you able to hear me?
Yeah, I can hear.
Okay.
All right. And just for my clarity, was he ever taken to the hospital?
Yes, he was.
And do you recall which doctor treated?
I don't remember.
Fair enough. You'd agree that Mr. Montana did stop for you, right?
Yeah. He did stop. Yeah.
You'd agree that he wasn't really resisting arrest, yes?
I mean, he was resisting arrest at the point of when I had to tase him to get him under control because he wasn't listening to commands. He wasn't obeying lawful orders. That's, is that not resisting arrest, sir? Would you not class that as resisting arrest?
Right, we'll get to that, don't worry. But for the
Okay.
start, when you originally saw him exit the vehicle, you'd agree that he wasn't resisting arrest, correct?
Well, yeah. Okay.
Sure. Okay, so let's go on to what you're speaking or referring to. Sorry, and how would you state that he was resisting arrest?
Because he had to be tased to be brought under control. All right. Somebody that's, compliant and, stands there with their hands up, faces the wall when given commands, isn't resisting arrest. You know what I mean? Somebody
Right.
that has to be tased, is resisting arrest.
Sure. So let's talk about why you tased him.
Uh-huh.
I'm sorry, give me one moment here.
Your Honor, this sounds like we're trying to investigate Officer Boscarelli's technique rather than the facts.
So it comes down to facts, absolutely. But to ascertain the validity of the warrant itself and the arrest report leading up to it, this isn't a trap. This isn't, you're bound by specific lines of question or whatever. This is to get a general view of the overall. What do you think?
But whether he was tased or not, does that really matter at this point?
Well, Your Honor, in terms of whether him needing to or not needing to be detained, if it was a lawful reason for him to be tased and detained, if he was actually resisting arrest because he was violating a lawful command,
Which has been asked
by
and
an
answered.
officer, I'm trying to explain. If he was following or disobeying a lawful command and therefore was resisting arrest and needed to be tased, then he would have violated the law and all of this would be moot because he could have been searched. We're trying to establish, of course, that all of the detainment as well as the tasing and resisting arrest wasn't actually established and he didn't violate the law in that capacity.
Oh yeah. The question is fine.
Sorry, before we get to the tasing, I just do want to confirm something because I think I was misinformed with regard to something. So I stated to the court that it was near a house. I was clearly wrong from your statement. Was it the parking garage near the courthouse?
No.
Where was it?
So if you do you know where Roy Lowenstein is, sir?
Yes.
Yes. And do you know where the police station is? on
Yeah,
Roy
so,
Lowenstein.
so
And
near
then
the Davis
behind that,
courthouse.
behind, I don't know if that's a courthouse, sorry, I've never been, but behind that there's a car park next to like, I don't know what, I can tell you what street it is, but I
A
can't remember. But
multi-storied one, right?
yeah.
Behind a big tall building?
Yeah.
Or, right, okay. Yeah, so behind the courthouse. Okay. You'd agree you're not aware if there's any signs there that says private property?
Honestly, I haven't looked. I couldn't tell you.
No worries. Okay, so let's go back to tasing so we can get a little bit back on topic.
Okay.
You'd agree that Mr. Montana was not being physically aggressive, right?
Okay, he was being passively. I don't know what the right way to say this is, right? If I ask you, to put your hands up so I can place cuffs on you and face the wall, and you constantly say, no, 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 I'm not doing it, refuse to do that, right? I don't know what you're getting at there. I don't know what that would be called, but
you'd agree that Mr. Montana wasn't being physically aggressive, right?
No, he wasn't being physically aggressive.
Right.
However,
it was verbal, right?
yeah, it was verbal,
Right.
but he was also refusing to obey commands.
Right. You'd agree that you're trained on use of force?
Yeah.
Does your department use the pyramid, the use of force pyramid?
Yeah.
Okay. So what steps do you take when analyzing whether or not you should move from hand-to-hand techniques or to less than lethal techniques, which is tasing someone?
Hand-to-hunting. Okay, so look, ask, tell, make, right? That's what we do. We do the ask, tell, make before we go to anything higher than that. The guy didn't have a weapon. He was unarmed. You're right, but he was still resisting arrest. And I asked him. I asked him many times. I told him what would happen if he didn't. And then eventually it comes to the point where I have to make him do that. And to do that, I have to use my taser, unless it's a lethal situation.
Okay, and I'm not going to get into whether or not you should use that force. That's not the purpose of this hearing.
Okay, so
however, I will go back a little bit. So you'd agree that earlier when I asked you if you know if there's any private property signs or anything like that, you weren't sure, right?
I haven't looked, to be honest.
Right. So you're not sure if it's private property or not?
Yeah.
Okay. So you told Mr. Montana that you were going to Terry frisk him because he was wearing a mask, right?
Yeah.
And you'd agree that you have to be in a public place when wearing a mask, right?
No.
I'm sorry?
So here's the situation, right? As I saw it, the guy got out of a car that was fleeing from police, right?
I'm sorry,
I didn't know.
That wasn't my question.
Hold on a second, right? Because the guy got out of a car that was fleeing from police, right? I don't know what the situation was. They could have just robbed a bank. I don't know, right? So he got out. I tried to detain him so I could find out what had just happened. Whether he was a passenger or not, that comes later. But he still has to be detained while I investigate the situation, regardless of whether it's private property or not. If he runs into private property, does that then mean that I can't arrest the guy? I can't Terry frisk the guy? I can't, put him in cuffs because it's private property? He came there from the street, so I don't really understand your question or your line of questioning, to be honest, or what the point is that you're getting to.
You can just answer my questions. You don't have to go on a whole dispute. Miss Raiden, sorry, will have the opportunity to ask you some more questions and clear anything up. But for the purpose of my questioning, if you could just answer them as I ask.
Okay.
Right. So the penal code, you'd agree that it states wearing a mask, hood, or other concealment device in public areas is outlawed, right?
If you say so. I don't have it in front of me, but if you say so.
And as stated earlier, because you went on this whole spew a minute ago, you'd agree that any report, it never states that the reason why you told Mr. Montana why he was being Terry frisked is because he was exiting the passenger of a pursuing vehicle, yes?
Of a fleeing vehicle, yeah.
Right. It never states on your report.
What do you mean it doesn't state in my report?
You'd agree that it doesn't state in your report that you told Mr. Montana one of the reasons why he was being Terry frisked is because he was exiting a vehicle that was being pursued by law enforcement.
The fellow was literally shouting at me that he was a passenger. I think he knows why he was being detained.
Sure, that's not what I asked, sir.
Okay, so, right, okay, you're right.
I'll ask again. Okay, you understand. What was your answer?
No, it's not in the report.
Sure. you'd agree that you testified today that you weren't sure if it was a private or public area, yes?
Yeah.
Right. Mr. Hall, do you have any?
I do. You stated that the defendant, he was in a vehicle that was fleeing police.
Yes, sir.
Now, was that vehicle ever shooting at police officers?
I don't know, sir.
Okay. Was that vehicle posing a danger as far as throwing weapons out of the car, or shooting weapons out of the car that you witnessed?
Again, I don't know, sir. I was asked, somebody asked for backup. I arrived
I'm
late.
just asking whether you witnessed any of that or not.
Yeah, I didn't witness that. I didn't witness any of the chase either. I just witnessed them. I arrived at the, as the chase went into the car park. That's when I joined the chase.
Okay, so at the time when the defendant, he left the vehicle, you
Yeah.
wouldn't have had any sort of suspicion that he was in a possession of a firearm or other weapon, correct?
Again, I don't know. No. Well,
So
the
at the
type-
time, you wouldn't have had any suspicion that he was in possession of a firearm or weapon, right?
well, yeah. The reason, the suspicion was that he did have that because he was trying to conceal his identity by wearing a mask.
Not my question, right? So I'll ask it again. So when he actually fled the vehicle, right?
Yeah.
At that point, you hadn't witnessed the vehicle shoot, right? The defendant didn't have a weapon in his hand. Did
Uh-huh.
you have any other suspicion that the defendant was in possession of a firearm or other weapon?
No.
Okay. Now, at that time, was he posing an immediate danger to any officers on scene?
Again, he was very angry and aggressive, so it was hard to tell where that would go. I don't have a crystal ball,
Okay. Now, you stated previously that you were in a garage.
Sorry, say that again.
You stated previously that you were in a garage. Is that right?
Yeah, a parking
Do you
garage.
agree
Yeah.
or disagree that a garage is a highway?
I don't know the ins and I'm not that technical. I don't know.
From a layperson's perspective, would you agree or disagree?
I don't know. I honestly, I couldn't tell you either way.
Okay. And what about a street?
Again, I mean, there's a road that goes into it, and people use it to park their car. So I don't know. I don't know what the technicalities are on that. Sorry.
Now, I'm all asking that because as a law enforcement officer, you are tasked with enforcing the law as written. And currently, as written, that's how it is written in the statute in terms of how you may stop and frisk an individual that is wearing a mask.
Yeah.
The individual must be on a highway, street, or in an alleyway. And as an officer, you are expected to know the difference and be able to apply the law correctly.
Okay.
Correct?
Okay.
So, would you agree that the defendant was in a public highway, street, or alleyway?
I would say it was more of a hot pursuit if you want to go down the road of it was private property.
Okay, well, again, the main point is even if it's a public garage, like you're asserting, it must be a public highway, street, or alleyway.
Okay.
Right?
Yeah.
Now, with that in mind, that's what you need to establish for the person to, one, be wearing a mask, as well as to be on a public highway, street, or alleyway. That's what you must establish as a law enforcement officer to actually stop and frisk an individual. Now,
So I don't know how to answer this question because it seems like it's semantics, to be honest. But it was a hot pursuit. So
okay, so you're asserting that the only reason that the defendant was being detained was because he was leaving the vehicle that was being chased by police. Is that right?
no, Andy was concealing his face.
Well, you're asserting that it's both reasons then, right? So you need to.
Your Honor, this has been asked and answered many times.
Your Honor, he's refusing to answer the question.
I'm not.
Mr. Haugensen, first of all, this isn't a trial. We can ask the question to ascertain the facts multiple times if needed. Secondly, Officer Boscarelli, can you just try and give a clear and concise answer?
Well, I don't know how to answer if it's a street, an alleyway, or a thing. It's a car park, man. You know
Can I
what
ask
I
a
mean?
question, Hall?
Yes, go ahead.
Okay. I'm just going to ask you a couple questions. I'll try to make this brief, and I know Mr. Hall has a couple more. So, in your law enforcement training, you'd agree that, or sorry, actually, I'll go on to the next question. You'd agree that it's pretty essential to know as a law enforcement officer the difference between a street or a highway, right?
Yeah.
Because speed limits are different, right?
Yeah,
A
of
highway
course.
might be 70 miles per hour, a street might be 40 or 30.
Uh-huh. Yeah.
Right. So, would you say that a parking lot is a highway?
No, it's a parking lot.
Right, exactly. Mr. Hall.
All right, thank you. Now, would you agree or disagree that in the parking lot, the defendant stated to you that his name was Carlos?
Yeah.
Okay.
He did.
Now, is there a statute that a defendant has to identify themselves to a law enforcement officer?
While they're being detained, or in general.
Okay. Now, I would like to quote off of that statute if I'm. Now, this is going to be PC 3315, failure to identify. You are legally required to identify yourself if being detained on reasonable suspicion that you committed or are committing or about to commit an offense. In addition, in a traffic stop, you are legally required to prove your name and license if you are the driver of a motor vehicle, regardless if an offense is committed or not. Failure to do so in a time and fine. Now, do you agree or disagree that the defendant in this case was the first part of this law? He was being detained not in a traffic stop.
Yeah, I agree.
Okay. Now, with that in mind, you again agree that the defendant, he identified himself as Carlos?
Yeah.
Is there anywhere in this statute or any other statute in San Andreas where it states that the defendant must state their full name when in a non-traffic stop detainment?
Well, I would say that would be implied by identifying yourself.
Would you agree or disagree that the defendant in this case identified himself as Carlos?
He identified himself with his first name, not his full name.
Again, did he identify himself as Carlos?
He did identify himself with his first name, yes.
Okay, no further questions from the petitioner, Your Honor.
Okay.
Mr. Haugensen, the state. Oh, anything you want to ask?
Yes, sir. Okay, officer. I'm going to ask a few questions that you've already answered.
Okay.
I'll ask them as simply as I can.
Okay.
You, as they have mentioned quite a few times, chase this subject or the suspect into a parking garage.
Yeah.
Multi-story parking garage.
That's correct.
Which I happen to know that garage is a public garage, correct? Anyone can use it.
Correct.
I
So-
dispute that fact that he said in cross-examination that he wasn't sure whether or not it was a private or public area.
Whether or not he knew it was or not isn't in question. The fact it is a public garage is in question.
Your Honor, we can save our points for a rebuttal.
All right, continue.
Anyway, what these guys over here, I forget what they're called again. Yeah. What Mr. Hall and Mr. Hunt asked you, they were stating law to specifically the one that you used to, well, one reason you used to Terry frisk the suspect, which
Yep.
was he was wearing a mask.
Yeah.
What they have said was it a road? Was it a highway? Well, it can be a lane, walk, alley, street, road, highway, or other public way. Does the road which it sits on have a driveway into the garage?
Yes, it does.
Would you consider that a way?
Yes, sir. It's connected to the main street so people can get into the parking garage.
Okay. So we have a public way. Brilliant. Also, with resisting arrest, you mentioned before that he was verbally aggressive and refused your lawful commands.
Yes, sir.
And that is when you brought him under control and detained him.
Yes, sir.
And then once he was detained, you then searched him. Correct?
Yes,
They're a
sir.
Terry frisk.
Yes, sir.
Do you believe you acted correctly within the law?
100%.
Yep. No further questions, Ron?
All right, Petitioner.
That's what it is.
If I can have a moment, we took some pictures of this parking garage earlier today. If I can submit those copies of the pictures to the court and Mr. Haugensen.
Didn't you state earlier you thought it was an apartment? How do you have pictures of something you didn't know about?
Would you like a copy?
I'd like to know how you got them when you didn't know about it. That's a bit weird.
That is a good point, but yeah, you can submit them on the motion.
Okay.
What?
I'll explain it. No.
Sorry, where are these pictures being?
I just have to confirm I have the right location. It's the location to the right of Davis PD, right? Because I thought that's the location we were speaking about.
If you have pictures of it, you should know.
Well, I'm ensuring that I have the right pictures because you're telling me I may not have the right pictures of the correct location.
Officer Boscarella, can you confirm the?
I can
location?
submit the pictures I have, and then we can go from there.
I believe it's the one off McDonald Street. There's a fire station on that street, and then the street ends at Roy Lowenstein, and then right at the end there's a parking garage. I believe it's marked on the map as well. But I might be wrong if that's not the right street.
Okay, I may have pictures of the wrong building. I can perhaps have somebody go down there quickly.
Yeah, I believe
but
it's Garage 28.
So it's listed as a public garage on the
Yeah.
map. Oh, nice.
Okay. Okay, I'll just ask you a couple questions, sir. And then maybe if we have time, we can get some pictures of the correct building. Mr. Haugensen asked you stated that he was chased into the parking garage. Yes?
Sorry, say that again.
You'd agree that you stated with Mr. Haugensen that he was chased into the parking garage?
Yes, sir.
And where is it that the vehicle stopped?
On the ground floor. So there's 3 levels. You go up like a sort of hump, and then you can either stay on that level or you go down a level, and then on that level at the very bottom, it's kind of like a basement level. People usually use that to escape because there's a little area where they can skid out. So the guy went down there, and that's where the driver drove down to the basement level part of the garage, and that's where Mr. Montana got out and then ran back up the hill of the ramp part of it up towards where the little yellow boxes where you pay or where you get your car out.
Okay. And sorry, I'll just make this brief so we're not going in circles here. What I don't understand is you told Mr. Haugensen that it was a public area, and then you told us that you weren't aware if it was a public or private area. So sorry, just for confirmation, which is it?
Well, it's a public car park. It's anybody can go there and leave their car. You were asking me specifically about who owns it. I have no idea who owns it, if it's public or private or whatever. But do you know what I mean?
I don't actually know.
Okay, well,
Sorry, I can clarify. So the sole presence of a parking lot doesn't necessarily mean it's a public parking lot. It's still owned by somebody. You have to pay for parking, right?
Okay, so who owns it? Do you know the owner?
I don't personally know the owner. No, that's what I'm asking, because you're telling well, you told Mr. Haugensen that you knew that this vehicle was stolen. I mean, sorry, you knew that this parking lot was a public area, and you told us that you're not sure if it was public or private.
No,
So
I
you
said
can
I
see-
hadn't. No, you asked me if I'd seen signs, and I said I wasn't aware. I hadn't checked. I haven't looked. That's what you asked me.
Okay, so how do you know if it was or wasn't a public or private area?
Because I just looked on the map and it's listed as a private parking garage. Sorry, as a public parking garage. Parking garage number 28.
I do have a question then.
Oh,
It's sort of an analogy, but as a law enforcement officer, you'd have experience in terms of knowing what is and not public and private property, right?
I mean, yeah, usually if it's like there's a business or like if there's like a shop front or something like that, or if there's staff there, you know what I mean?
Okay. Now, as far as I'm going to throw in an analogy here. Let's say you walk into a flower shop. This building,
Yeah.
it's owned privately,
Yeah.
but you're able to go in there and you're able to buy some things in your public and private capacity.
Yeah.
Now, is that public or private property just because it's open to the public?
It would be private property because it's owned by the flower shop people.
Exactly. Because it's owned by someone, just because it's free for the public to use and try and coordinate a service with that that organization. It's still private property, right?
Yeah, but I mean,
But with that in mind, a parking garage, generally a parking garage, they need to make money off of parking, people being able to park there, right?
yeah,
Therefore, it is a business, correct?
I don't know. Potentially,
Well,
it could.
They make money
it could be.
off
It
of
could.
people parking there, right?
Yes, but that doesn't tell me who owns the building, if it's the state or if it's a person that owns it, just because they charge to park there. You know what I mean?
Okay, so we can clarify that you don't know, right? That's what you're saying. You're not sure. You're not sure
Yeah,
if the state
I'm
owns
not.
it or if it's privately owned.
Well,
So
I have a suspicion it's the state that owns it.
but you're not sure, right?
I'm not sure because there isn't staff there to ask. There isn't a company name. There isn't anything like that anywhere in the building that would say, okay, so if I have a problem with parking here, I need to contact this company. It's just a plain 4 or 3 level building where you park your car.
Right. So you'd agree that you told somebody that you were going to Terry frisk them because they were wearing a mask, and you weren't sure whether or not it was a public or private area.
Can I just reiterate that that was not the only reason he had?
All right.
Sorry, sir. Can you answer the question? You have water too? Oh, what are you guessing? Sir? Officer?
Sorry, I'm sorry. Can you repeat that? I'll stand back here again.
No worries. I just asked. So you'd agree that you told somebody that you were going to Terry frisk them
Yeah.
because they were wearing a mask, but you weren't sure if they were in a private or public area, right?
Yeah.
Okay. I have no further questions, Your Honor.
Okay.
All right. I don't want to be here all day and going back and forth and back and forth. Does the state have any other questions?
No.
Right, Officer Buscarelli, I appreciate you coming down here. Well, you can either take your seat or you can leave. It's entirely your choice.
I'll sit there and see where this goes. It'll be interesting to see. But, thank you for your time, and gentlemen, thank you for your time. It's my first court case. I appreciate you. I appreciate you guys. Take care.
Sorry,
Thanks,
this
Pascal.
would be your first one.
All right. Is the other officer named in the affidavit here? Officer.
He's had to
Raiden?
leave due to ill health, Your Honor.
All right. No problem. This is definitely an interesting one, and it's layered. It's not as straightforward at the very beginning. The petitioner gave two reasons why they really wanted to challenge, or the main two reasons. But as we've kind of gone on and gone up, it sort of peeled and opened up like an onion. It's just multi-layered and quite fascinating to listen to. I will see. I am going to take a reset. I'm going to aim for no more than about 10 minutes. But there is a lot of information to go through and look at. And then I'll come back and we'll decide on the validity of the warrant.
Hi, Garner. Just to make you aware, I'm doing my best to get the client down here if the warrant is to be found valid, so the warrant can be executed by law enforcement.
All right, no problem. All right, we'll take a short recess. Where's the petitioners gone?
I do not know, Your Honor.
They are outside. I believe they're looking for Carlos
All right,
Montana.
we'll give them a minute. Where the hell did my phone go?
Hello, Your Honor.
How's it going, Mr. Rob?
You stole his phone? Interesting.
Apologies, Your Honor. I forgot I didn't have a set of keys to freely enter and exit anymore.
Yeah, you're fine. Just waiting for Mr. Hall.
Just to make you aware, Mr. Hall is just waiting outside. Mr. Montana is just a minute or two away.
All right. Do you want to wait for Mr. Hall, or are you okay to proceed?
If you would like to get it going, I can proceed, or I can call Mr. Hall and ask him how long he'll be.
All right, well, I'll get started. So, as we discussed, in order to invalidate a warrant based on false or misleading affidavit, the defendant must show that the person applying for the warrant either deliberately or recklessly misled the judge, and that without that, there would be no sufficient matter in the actual affidavit to support the warrant itself. And where the warrant application is based on either falsehoods or reckless disregard for the truth, then that's where it becomes an issue. Recklessness isn't measured by the relevance of the information, but the demonstration that there's willingness to, affirmatively obscure or distort the truth, which that equates to reckless disregard. So one thing I just want to note before I go through everything, one of the arguments was that the individual was wearing a mask inside a vehicle on the road. Inside of vehicles, those are private property. A person's vehicle is private property. If they weren't, then there would be no need for a search warrant to search the vehicle. So I just want to get that out there first. Now, when you're evaluating a warrant, there's 4 doctrines that must be met. Those are reasonableness, probable cause, judicial authority, and particularity. So let's first talk about the legislation mentioned. The state mentioned that it had not been enacted. In San Andreas, when a new legislation is posted in the manner that the one referenced was, the date and timestamp on the legislation is accepted as the date and time of enactment. So, as such, the court sees no reason to uphold that part of the motion. Secondly, we need to analyse the area in which the search was conducted. Was it a private area or was it a public area? Well, the arguments have been in depth and questioned, re-questioned, questioned, re-questioned, and debated to great length today. The area in question is indeed a public area. However, the next issue that arises is the uncertainty of Officer Boscarelli as to whether or not he was indeed entering private or public property. Now, in all situations like that, it would be assessed on a case-by-case basis. Given the uncertainty of whether the area was private or public, we then need to look at the possibility that it was private, and then evaluate other exigent circumstances that come from the defendants. And the circumstances include the flight itself. But pursuit of an individual does not trigger a categorical rule that allows a warrantless entry into a private space. However, the totality of the circumstances surrounding this, the visual pursuit of the individual, whether they were the driver or not, fleeing on foot would give any reasonable officer the belief that a pursuit is warranted. So as such, we see no reason to uphold this part of the motion. We then need to look at the veracity of the warrant itself. The petitioner stated that the search warrant was overbroad, and the warrant stated an overbroad general search of all of Mr. Montana's vehicles. To prevent the abuse of indiscriminate rummaging, as it's put, the Fourth Amendment requires each warrant to particularly describe the place to be searched and the persons or things to be seized. As per the US Constitution's Fourth Amendment, that means that search warrants must be specific. Specific in terms of a warrant has two aspects: particularity and breadth. Now, not only does it have to clearly state what is sought, the scope must also be limited by the probable cause on which the warrant is based. In evaluating this warrant, the court will accept that it was overbroad. But aside from the overbreadth problem, the facts in the supporting affidavit were too stale to support the proposition that the search would turn up any evidence of wrongdoing. Now, under a staleness doctrine, an affidavit supporting a search warrant must be based on facts so closely related to the time of the issue of the warrant that it justifies a finding of probable cause at that time. So while a significant gap in time can diminish the probability that the evidence will be uncovered in the search, a warrant must be upheld if there is sufficient reason to believe that, based on a continuing pattern or other good reasons, behaviour, the items to be seized are still on the premises. Detective Arnham's affidavit provides no real reason to suspect any ongoing criminal business that justifies the lapse of time between the date of the incident, which was September the 4th, 2021, and the date of the warrant, which was September the 6th, 2021. That's a period of 48 hours, which at that point, given the circumstances and the small nature of the crime that led to the search, would render that affidavit information stale. Now, secondly, on the warrant itself, the grounds of the warrant, where it's possessed by a person with the intent to use it as a means of committing a public offence, or is possessed by another to whom he or she may have delivered it for the purpose of concealing it or preventing its discovery, as was brought up by the petitioner. The firearms in question were already seized. On the search itself, those items were seized. Now, on the warrant itself, there is multiple options. And in a case such as this, if the warrant were to be held, the option that would have been checked was, it is believed to be harbouring or concealing evidence of a crime. As such, based on the overbreadth, the grounds in which the warrant was issued, and the staleness of the information given the lapse of time, this court is going to find that that warrant is invalidated. And you are all free to leave. And dismiss.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.